I filed a motion to modify probation as well on another case that she has. We were having problems with e-file yesterday, so it may have been very late in the day. I don't know if it made it, but it's...
I received it this morning, Your Honor. I can tell you what it is. We kind of discussed this with Ms. Simmons earlier this morning. Ms. Taylor pled a couple months ago on, I think, 2 other cases, and got probation. She was ordered to safety. Before she could get sent to safety, this case got indicted and that kept her here. This case was indicted about a month ago, first week in November.
Okay. Offense date of?
March, predates what we did before.
Predates it, okay.
It was part of the backlog of testing from the lab.
Yeah, and so the agreement on this one is?
To run concurrent with what she's doing, which, I think this is a 10-year deferred, concurrent with what she's already doing. Mr. Galmore's position is that since she's had to wait a few extra months in custody and not able to go to safety as ordered, he's asking that safety condition be switched to maybe ISF or something else if the court deems appropriate.
So what I would do at that point is it would get reset for sentencing and they would have to do a new substance abuse evaluation. If you want me to, I need probation's input. If their recommendation previously was for safety, then she hasn't received any treatment. I understand that she's been in custody, but that's not treatment. And so if she's going to get a probation on a possession to go along with that, there's going to be some treatment, and I would anticipate it would be in custody treatment.
And that's what my motion on the motion to modify probation was suggested, was an alternative treatment program that just may be shorter. I think the real reason for the argument would be the fact that she is farther removed from her drug use at this point than it was originally considered.
I would consider ISF, but I'm not going to do outpatient. I think we need something with 2 felony probations that's a little more intensive.
The shorter ISF program would probably be about the same amount of time that was originally planned for her to be in custody anyways.
Right.
And so that was one of the requests that my motion made in the motion to modify, and then we left the treatment plan on this plea up to the court.
So is there any reason to get even an updated pre-sentence report? I can just go ahead and do all of this.
She's been in custody this whole time, so there's nothing that's been changed. Right. I know of no major disciplinary problems or anything like that, so I would ask the court to go forward today.
Okay, all right, let's take care of the new case and then we'll discuss the modification. Then, you're Melissa Taylor.
Yes, ma'am.
And Mr. Galmore, will your client waive the formal reading of the indictment?
Sure, Your Honor.
Ms. Taylor, in cause number 25 DCCR 1693, you're charged with a 3rd-degree felony offense of possession of a controlled substance from March 9th of 2025, and how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Galmore?
Yes, ma'am.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And the agreement is for a 10-year deferred probation. Is there no fine on this one?
I'm okay with waiving the fine.
All right, there would be no fine on this case, and you would be required to follow all of the rules and conditions of probation, which, as you guys have said, is unagreed as to treatment, but that we've talked about. What I'm inclined to do is the substance abuse track of the ISF program. Is that your understanding?
Yes.
And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Any evidence that Ms. Taylor is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. I am going to waive the pre-sentence report. I'm going to find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings for a period of 10 years. You're ordered to follow all of the rules and conditions of probation, which include entering and successfully completing the substance abuse track of the ISF program. In addition, as your follow-up treatment, when you get out, you will be required to enter and successfully complete the JCDI program. So you're going to get out, you'll have all the tools. You're going to get tools while you're in custody. You're going to get out, you're going to have even more tools so that you can be successful and get off drugs for good be a productive member of society, and not end up with felony convictions on your record and going to prison. And if you do all of that, just like we talked about in the other case, this is a great opportunity because you don't have the conviction on your record. If you successfully complete the probation, the case will be dismissed. You'll never have a felony conviction. The other side of that is if you violate any condition in this case, you'll be brought back into court, you could be found guilty, and you could go to prison for between 2 years and up to 10 years. Do you understand?
Yes, ma'am.
All right, I'm handing you, in that case, the trial court certification that shows that this was an agreement that I followed, so you waived your right to appeal. Yes, ma'am?
May I speak?
Let me, hold that just a second. Let me take, because I'll get sidetracked and then I won't do what I need to do legally. So now, for probation in cause number 24, DCCR 2311, I am going to grant that motion to modify the probation order to change that from SafeP to ISF, substance abuse with JCDI as aftercare.
Will you give me the call number?
24 DCCR 2311.
Judge, I think there may also be another probation that she's on, a different cause number.
I'm not sure.
I thought we pled her to a state jail and a
Can y'all look,
higher level
please?
felony. I just don't want, I don't want to get skipped over if there's another.
If she's on probation for more than that one, if there is another, and then the same order goes for all. If it was SafeP, that can be
I know it's this one or two.
switched from SafeP to ISF substance abuse with JCDI as a, the problem is if it's do y'all think there's one? Because it might be the time that she's on probation could be an issue.
I
Okay.
could be wrong.
Okay, we'll double check it. If she is, that'll be a condition. It'll be switched from SafeP to ISF also. Okay, yes, ma'am.
Yes, ma'am. So I have been incarcerated for the last 8 months in Jefferson County Correctional. During the last 8 months, I've held a trustee position for 6 of those 8. There are no programs for rehabilitation for women like myself that spend 8 to a year incarcerated. There are none. The completed literature that I put down, I went out of my way to obtain that, get those shipped in to me, to reach out to an outside sponsor to review my packets that I went through. I have, whether you go to a 9-month program, a 6-month program, or a 3-month program, the desire of the individual to change and putting these into application are what actually creates lasting change. Otherwise, they're just books that I've read.
Sure.
If you can ask me anything about these books, and I can tell you how I've changed and how they've changed me and what they've done. I realize that my addiction is a terminal disease that will kill me. And it is a lifelong recovery process. And that if I don't completely abandon myself to my higher power in a recovery program for the rest of my life, that I will end up in prison or dead. I don't have any more options. I agree that I will most likely learn something from ISF. I will learn from any program that I'm ever put against. But I am begging you with the...
After spending 8 months behind bars, she makes one desperate plea that could change her future forever. But will the judge believe her or send her down a different path?
We sit in there and we eat and we gain weight and we watch movies and it's a vicious cycle. I understand the triggers and what made me relapse. I have a phenomenal support system, and I am willing to go so far to say that if you give me the COLA program, and if I fail, take this all away and put me in prison for 5 years. The effort that I took, seeing that there's no options for female inmates other than an AA program every other week at best. We sit in there and we eat and we gain weight and we watch movies and it's a vicious cycle. I understand the triggers and what made me relapse. I have a phenomenal support system, and I am willing to go so far to say that if you give me the COLA program, And if I fail, take this all away and put me in prison for 5 to 10 years. Don't have it an option.
Mr. Nichols, so
Big red letters on
So
the
here's the
file.
thing, Ms. Taylor, the words that you're saying
Right.
are, I mean, I can tell that you're sincere. I hear people say those words somewhat often. I wish more. Sometimes I feel like they're sincere, others I don't. I agree, there are not programs because jail is just a rotation of coming and going, and it's hard to get programs going because by the time someone gets started, they're probably leaving, and it could be better. I appreciate what you've done. I'm inclined, but here's my fear, is that I don't want to do what you're asking and set you up for failure. So if I do what you're asking and you violate, there's going to be a notation about all of this. Mr. Nichols will remind me, probation will remind me, and there won't be, okay, now I need SafeP. Now I need ISF.
I'm
Mr.
that
Nichols?
dedicated to my recovery.
You know, I usually have a pretty good memory for these things, Judge. If the court wants to give her that shot, I don't want to have to revoke her. I want her to be successful. I've read what she provided the court. I know it's impressive, the work she's done for herself while in jail. I'd hate to see it all fall apart, though. I mean, I think the case she's on, other case she's on probation for is assault on an officer. And I know there was at least one state jail.
I do have, so
drug-related
24 DCCR 2177 is another, she's on probation for. There is another probation. And so 24 DCCR 2177, so whatever I do to modify conditions are going to be the same on those. So I guess what I'm going to do, Ms. Taylor, is I'm going to give you this opportunity. It's 100% up to you to take it. Otherwise, you have 3 felonies that you're going to go to prison for.
I will be a success.
And here's the thing. If you feel like you're slipping and you need more and you go say, I need SafeP or I need ISF before it ends up with me, that's one thing. That's a hard decision to make. But if you're truly committed to it and you feel yourself slipping that you need inpatient, it's going to be up to you to make that decision to ask for it. If it gets so far that you're here, it's going to be too late. All right, so then I'm going to modify the conditions of all of those probations, including the new case, to order that Ms. Taylor enter and successfully complete the JCDI program and not have to go to ISF or SafeP in any of them. So take advantage of this. I did everything else.
I think so.
All right, good luck.
Yes, ma'am.
There's two old probations, the 2 prior ones, and 1 new one. So we've got 3. All right, so we're going on.
Count is a third degree.
Okay, so more of it. All right, so are you Perry Robertson?
Yes, ma'am.
And will your client waive the formal reading of the indictment in each case?
They are.
Mr. Robertson, in cause number 25 DCCR 0498, you're charged with the state jail felony offense of evading arrest or detention with previous convictions, and that's from March 23rd of 2025. The indictment alleges you were previously convicted of evading detention February 23rd of 1998, and then again January 10th of 2000. And then it further alleges you were convicted previously of possession of a controlled substance, a state jail felony, April 22nd of 1999. Then after that was final, you were convicted of delivery of a controlled substance, a state jail felony, November 20th of 2000. And then after that, possession of a controlled substance, a state jail felony, November 4th of 2003. And then convicted of 2 delivery of controlled substance, state jail felonies, June 13th of 2005. After that, convicted of possession of a controlled substance, a state jail felony, February 19th of 2008. Again, convicted of possession of a controlled substance, a state jail felony, April 12th of 2010. And unauthorized use of a motor vehicle, January 7th of 2010. And then finally, possession of a controlled substance, a state jail felony, July 29th of 2024. And how do you plead to that charge? Are all of those prior convictions true? Did you enter your plea of guilty and true to all of those convictions freely and voluntarily?
Yes.
And because they're all actually true?
Yes.
All right, I do want to know, what was that what did he get last year?
Wait, I believe,
Possession of a controlled substance, July 29th, 2024. Cause number 24, DCCR 0025.
State jail.
State jail.
State judge,
State jail
give me
time?
a second.
Yes, state jail.
Okay. You ever been to TDC on any of these cases? Okay. So you understand if I follow that agreement, you're waiving your right to appeal, right?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number one.
No objection.
It's admitted. Is there any evidence that Mr. Robertson is not competent?
No, Your Honor.
And the agreement is for a dismissal in 0499, correct?
No, there's
No,
there's
he's
two
pleading.
cases.
Two cases, Judge.
What did I just read?
CC.
Oh, to run CC. Sorry. Let me go through. So then, that helps me. Hold on. I got to write this. All right, in cause number 25, DCCR 0499, you're charged with, give me a second, the state jail felony offense of burglary of a building from March 7th of 2025. This indictment alleges all of those same prior convictions that I read out previously. And how do you plead to this charge? And again, are all of those prior convictions true? And are you entering your plea of guilty and true in this case freely and voluntarily? State tenders number one in that case as
No
well.
objection.
It's admitted. Any evidence that Mr. Robertson's not competent?
No, Your Honor.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. And cause number 25, DCCR 0498, find you guilty of the state jail felony offense of evading arrest or detention with previous convictions. Find those prior convictions true. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 25, DCCR 0499, also find that you entered your plea of guilty freely and voluntarily and those pleas of true. Find sufficient evidence to find you guilty, and at this time find you guilty. Find those prior convictions true. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you in each of those cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. They will run concurrently, which means together at the same time. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right? Good luck to you, sir. You can go back with Bailey. Good morning. Are you Burton Edward Bailey?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He will, excuse me, he will, Your Honor.
Mr. Bailey, in cause number 25 DCCR 1380, you're charged with the state jail felony offense of theft of property with previous convictions, and that's from August 9th of 2025. The indictment alleges you were previously convicted of theft May 13th of 1991, and then again January 11th of 2024, and then August 29th of 2024. And then it further alleges that you were convicted of possession of a controlled substance, a state jail felony, October 2nd of 2008. And after that was final, convicted of possession of a controlled substance, a state jail felony, October 26th of 2011. Convicted of delivery of a controlled substance, a state jail felony, May 11th of 2012. Convicted of possession of a controlled substance, a state jail felony, October 5th of 2018. And then convicted of possession of a controlled substance, a state jail felony, July 31st of 2024. And how do you plead to that charge?
True.
Well, are you guilty or not guilty of the theft?
Guilty.
Okay, and are all of those prior convictions true that I read out?
Yes.
All right, did you enter your plea of guilty and true freely and voluntarily? And did you plead guilty and true because you actually did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes.
Do you fully understand them?
Yes.
I need to know what some of those prior punishments were. I feel like this is incredibly low for that amount of criminal history.
I'll let you know, Judge, that we took into account, I'm not sure prior with you, but we took into account, and Mr. Rojas can speak to this, the nature of the underlying offense, a theft of clothing and cleaning supplies, Your Honor, from a, I forget the name of the establishment, but nevertheless, to answer the court's question, well, here, I'll just give you this.
Well, let's start with the last one from just July of a year ago, 2024.
77 days on that particular charge.
Okay. And then that's the only Jefferson County. We've got some Tarrant County.
In the interest of full disclosure to the court, it does have a 1994 federal conviction for what they term or refer to as take motor vehicle by force. He did 140 months on that. And then on his supervised release, when he was released from that 140 month sentence, his supervised release was revoked to a 10-month sentence, Judge. Again, the state's thinking was the underlying nature of it.
No, I understand that. I just, do you know the Tarrant County?
What year was it?
The 18, there's one from 18.
I'll show a POCS from 2018. He did 6 months in jail.
Okay.
Probably state jail.
Yeah, they were all state jail, so it's,
He does have one real felony that he did 5 years on. That was back in 1991, Judge. It's an older.
That's right.
okay,
That in the federal case are the only substantial time he's got.
okay. All right, Mr. Bailey, do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Bailey is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of evading arrest with previous convictions. Find all of those prior offenses true. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff. Thank you. Thank you, Mr. Coleman and Mr. Rojas. Good morning. Are you Tristan Calhoun? And will your client waive the formal reading of the indictment in each case?
He will, Your Honor.
Mr. Calhoun, in clause number 25, DCCR 1216, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from August 2nd of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And because you did what they charged you with? And then in clause number 25, DCCR 1217, you're also charged with the second-degree felony offense of aggravated assault with a deadly weapon from August 2nd of 2024. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily? And because you did what they charged you with? Bless you. I have here on the tablet some documents that have your signature on them in each of these cases that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreements that you've reached with the district attorney's office, you will be waiving or giving up any right to appeal?
Yes, ma'am.
So you can't change your mind if I follow the agreement. You understand?
Yes, ma'am.
And it looks like the agreement that you've reached in each of the cases is for 7-year deferred probations. There would be $500 fines. There would be, you'll be required to follow all of the rules and conditions of probation, including paying any restitution that would be determined between now and when we come back for sentencing, and also having no contact with the victims in either of the cases. Do you understand?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Calhoun is not competent?
No, Your Honor.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your case, both of them, for sentencing so that the probation department can do a pre-sentence report. Again, that'll give me more information about you, your cases, determine any restitution, and then we'll come back later for sentencing. What's the state's position, Ms. Malfino, with regard to bond based on the nature of those plea